understand the reasons.
Yeah, just to be clear, Your Honor, I had gotten Mr. Nichols to extend an offer of 4 years, which Mr. Carter was prepared to accept, and that's when I set it on the docket today to plea. I was contacted by Mr. Nichols yesterday and advised that he was withdrawing that offer based upon the jury I've been provided with, and that the offer was now 6 years and with a 7-year cap, and Mr. Carter's previously refused 5 years, so I did another refusal.
So, Mr. Carter, how old are you?
17.
17 years old. And do you realize now what you acting up in jail has already cost you? Do you really? Tell me what it's cost you. Well, some of your life. But you had already talked about a deal in your case that sounds like you were going to accept. Is that right? And because you can't behave and follow the rules in jail, and I get those reports, and the district attorney's office gets those reports, and your attorney gets those reports, they decided you don't deserve that, and I don't disagree with them. So here's what happens now. If your case goes to trial, and I'm going to go through some things in a few minutes about that, and you get found guilty in that trial, that jury can also hear all of those reports, every last one of them. And if you think this man right here ain't going to bring those in and show that jury why you don't deserve any mercy or whatever, he's going to do it. I would if I were him. So if you're going to be in front of a jury, or you're going to be in front of the judge, or someone who's deciding what happens to your life, you might ought to change what you're doing in that jail. I just had a talk with another young one. I don't know what's going on in that dorm with all of you young ones, but what y'all all need to do is look at each other and say, I don't want to go to prison for a long time. If you do, you go act up over there. And man up and say, I'm not going to behave like that. Because you're a man now. And you're in felony court. You don't feel like a man. Your brain's probably not functioning like a man, but you are in felony court like every other grown-up man. And if you make kid decisions and think that horse playing and treating the people that are trying to work there the way you are is going to get you anywhere, it will. It's going to get you in there longer. Does that make sense? So what you're charged with is the 3rd-degree felony offense of deadly conduct discharging a firearm from October 13th of 2024. And what that means...
Judge, I'm sorry to interrupt again.
Yes.
He has a juvenile adjudication, which he is actually on parole for.
Felony conviction.
And it's a felony conviction. My understanding, and I need to file the proper notice, my understanding is that can be used to enhance him to a 2nd degree. I don't think it precludes him from maybe getting probation from a jury. I need to make sure I vet that out through the family code.
Okay.
But my understanding is he's looking at a possible 2nd degree punishment range.
Do you agree with that?
It's a hybrid situation with the prior juvenile felony conviction. I think that Mr. Nichols is correct that it precludes, or it does not preclude him from having to be eligible for probation from a jury. However, it will enhance the punishment range from a 3rd degree to a 2nd degree.
So, Mr. Carter, what that means is that if you go to trial and a jury finds you guilty, and they find that that previous adjudication took place and was true, that you were adjudicated as a juvenile of a felony, that means that jury can sentence you anywhere in the range of punishment of a 2nd degree felony instead of a 3rd, which is between 2 years and up to 20 years in prison. Do you understand? And I have a plea bargain rejection that you've signed with Mr. Kimler that shows that the district attorney's made an offer, if you wanted to enter a plea of guilty, for a 6-year term in prison or for a 7-year cap to me. You have every right to reject that offer and have your case set for trial. We've talked about all that. Do you want to reject that offer and have a jury decide? Okay, then we'll get your case set on the trial docket as quickly as we can. Again, don't get over there and forget what I told you today. It's very important. Do you understand? 9-1. The state's elected to proceed on count 1 only. It alleges you committed the 3rd-degree felony offense of assault on a public servant, and that is from August 19th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
This is a critical moment where everything shifts. The defendant enters a guilty plea in a felony assault on a public servant case. Legally, this is more than an admission. It means giving up major constitutional rights, including the right to a trial. The key question at this stage is whether the defendant truly understands the seriousness and long-term consequences of that decision.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? See, state tenders number 1.
No objection, Judge.
It's admitted. Mr. Falk, I'm going to find that you entered your plea of guilty freely and voluntarily. Find again that you're mentally competent, you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of assault on a public servant, third-degree felony. Sentence you to, in accordance with your agreement, to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff. All right, are you Kevin Tran? And Mr. Tran, in clause number 2137560, 2138780, 25 DCCR 0422, 25 DCCR 0423, 25 DCCR 0424. I'm going to take judicial notice of the files in all of those cases. Looks like the first 2 cases he's on probation, and then we've got new offenses as well. Mr. Tran was evaluated for competency to stand trial by Dr. Grappon. I received that report dated July 21st of 2025. The finding in that report is that Mr. Tran is currently not competent to stand trial, and that inpatient restoration would be called for. Is there any other evidence with regard to competency?
No, Your Honor.
All right, then based on that report at this time, I am going to find that Mr. Tran is not competent to stand trial, find that inpatient competency restoration is required, and order that he be sent to the appropriate facility for a period of not to exceed 120 days from the date he gets to that facility, and then we'll await a report. Mr. Tran, we're going to try to get you some help so that you can understand everything that's going on, and then we'll get you back in court as soon as we can. You can go back with the bailiff.
This is where the system changes direction completely. The court determines that the defendant is not competent to stand trial and orders inpatient restoration. This does not dismiss the case. It pauses it. The focus now shifts away from punishment and toward mental health treatment, allowing the defendant to receive help before the legal process can continue.